I appreciate the opportunity to address the group this evening via video. Life tends to throw us curves, and the best laid plans of mice and men oft go astray. Family matters require my presence elsewhere, and this is the best alternative I could come up with. If the good Lord allows, I will show up in person to preach later this year, but I wanted to avail myself of this opportunity and do the best I can to keep faith and address some issues of great importance. The first half of the 114th session of the General Assembly was a dud with respect to any movement to restore our pre-existing Second Amendment rights. The legislature did not advance the ball down the field on a single issue of restoring the governmental stolen rights of the people to bear arms. I will list by cause those good bills killed in the House, the Senate, and by virtue of the legal department, which writes the bills the legislators bring as ideal in legal terms. A quick note. Some will offer, look at us. We killed a lot of very bad bills brought by Democrats this year, to which I respond, really? You want to be patted on the back for being responsible and standing in the breach to deny Marxists to take over our state? Don't attempt to use your constitutional duty to your oath as a shield for failure to advance liberty by saying you prevented more tyranny. Bills that the House killed this year. Second Amendment as a civil right, House Bill 0554 by Kip Capley. Voting no in committee were Davis, Johnson, Stinnett, and Travis, all Republicans. Simply put, it would have codified the Second Amendment as a right protected by the constitutions of this state and the Union. It would allow suits against government officials that invade that right. It would not have placed police in danger of being sued while operating under their duty. Currently, such suits are allowed under federal law. In 2010, the Supreme Court of the United States incorporated the Second Amendment against the states through the Due Process Clause of the 14th Amendment. The power to regulate the wearing of arms with a view to prevent crime was stripped from the General Assembly at that time. But who pays attention to federal Supreme Court mandates? Not the General Assembly of Tennessee. Bills the Senate killed this year. Senate Bill 1407 by Hensley, use of deadly force to protect property. Republican Senators Rose and Gardenhire voted with the two Democrats to kill it in committee. Counterpoint, Oklahomans can now legally point a firearm or other weapon at someone if they are defending their home, private property, or business under a new law signed by Kevin Stent, governor. House Bill 2818 expanded the justified defensive display of a firearm or other deadly weapon to include defense of property. Texas has always allowed the use of deadly force to protect personal property. Such an action is a crime in Tennessee. Senate Bill 1227 by Lowe would move long guns into the enhanced carry permit field. Again, Senators Rose and Gardenhire voted with the two Democrats to kill it. From 1796 till 1989, it was lawful to carry long guns for all lawful purposes. The feckless legislature had already limited by statute the ability to carry knives and handguns starting in 1801, but long guns were allowed. The Heller Court quoted the Tennessee Supreme Court from a case in 1871, a year after the Jim Crow intent to go armed edict was placed on our books, and after the legislature was given the power by law to regulate the wearing of arms with a view to prevent crime, a dodge simply to keep the freed black slaves from being able to bear arms for protection against the KKK. This quote proves the point. From Heller. In Andrews v. State, the Tennessee Supreme Court likewise held that a statute that forbade openly carrying a pistol, publicly or privately, without regard to time or place or circumstances, 50 Tennessee at 187, 1871, violated the state constitutional provision which the court equated with the Second Amendment. That was so even though the statute did not restrict the carrying of long guns, close quote. This in the patron state of shooting stuff. Bills that the legal department killed this year. Chris Todd's repeal of intent to go armed was never even brought out of the legal department, so that it could not be presented. This bill would have done away with the intent to go armed clause, as well as codifying a federal district court's order, which the state agreed with when Attorney General Jonathan Skrmetti signed it. The agreement states the challenge scheme regulating the possession and carrying of handguns that restricts individuals aged 18 years old to 20 years old from carrying handguns or obtaining permits to carry handguns on the basis of age alone violates the Second and 14th Amendments to the United States Constitution. There's nothing in that order that right be extended only to those with enhanced handgun carry permits under 3917-1351, but Representative William Lambert passed a bill this year at the insistence of the Department of Safety that allows only that subset of 18 to 20-year-olds to be able to enjoy that right under the Second and 14th Amendment. That was House Bill 1332. I personally asked the representative to include those individuals covered by 1366, the concealed only carry permit, and 1307G, constitutional carry, but he refused to do so. That does not comport with the orders of the federal court. Todd's bill never made it out of the legal department, as they did not develop a written version that allowed the non-criminal citizen to enjoy those rights. Monty Fritz proposed legislation that would have allowed long guns into the permitted status, would also have allowed brandishing to protect private property and criminal immunity in the use of self-defense. Currently, there is no right for the application of self-defense in Tennessee. If you are forced to use a firearm that results in the death of an assailant, you are guilty of manslaughter at least, and the person so charged is required to prove to the trier of fact, a jury, that they were justified in so doing. In other words, you are guilty until proven innocent. The Heller, McDonald, and Bruin Supreme Court cases emphatically state that self-defense is a right. Quoting from Bruin, in Heller and McDonald, we held that the Second and 14th Amendments protect an individual right to keep and bear arms for self-defense, close quote. Once again, Tennessee don't need no orders from the Supreme Court. The bill, opposed by every department of the police state, the Department of Safety, the TBI, and the Tennessee Attorney General's Conference, was never able to be brought to notice. In a meeting in Representative Fritz's office to discuss the legislation with Elizabeth Stroker, the legislative director for the Department of Safety, Patrick Powell, policy director for the TBI, and Stephen Crump, executive director of the Tennessee Attorney General's Conference, John Harris, Representative Fritz, and myself issued one of the very best lines that has ever been delivered. Ms. Stroker opined as to how her department was philosophically opposed to the bill, and Representative Fritz allowed as to how she did not get to be philosophical, only constitutional. She was highly insulted, but he was completely correct. The Tennessee Constitution in Article 2, Section 1 states, the powers of the government shall be divided into three distinct departments: the legislative, executive, and judicial. Section 2 of that article says no person or persons belonging to one of these departments shall exercise any of the powers properly belonging to either of the others, except in cases herein directed or permitted. None of these three groups who oppose on a regular basis the restoration of the Second Amendment rights is part of the legislature, and it has sole delegated power to make law. The Department of Safety is a part of the administration, the governor's office. The TBI, who knows who they work for, but they are not legislators, and the DA's conference are simply supposed to apply the law, not make it. In fact, they're all taxpayer-funded lobbyists working against the interests of the people. Finally, once again, the House failed to move the constitutional amendment that would return Tennessee to the original construct of our 1796 Constitution. The 1796 Second Amendment analog of that document, referenced by Thomas Jefferson as the least imperfect and most Republican of all the documents he had seen, and this has to be true, that statement is posted on the Tennessee Secretary of State's website, said simply that the free men of this state have a right to keep and to bear arms for their common defense. Simple, direct to the point statement of the promise to future generations of Tennesseans from men who had just had to shoot their way out of tyranny as volunteers with their personal long guns. They prefaced this promise by stating the Declaration of Rights hereto annexed is declared to be a part of the Constitution of this state and shall never be violated on any pretense whatever, and to guard against transgressions of the high powers which we have delegated, we declare that everything in the Bill of Rights contained and every other right not hereby delegated is accepted out of the general powers of government and shall forever remain inviolate. Inviolate. And yet the legislature has been about the business of violating their oath ever since. And we allow them to get away with it because we are lazy and scared to use the authority the founders bequeathed to us when they wrote that all power is inherent in the people, and all free governments are founded on their authority and instituted for their peace, safety, and happiness. For the advancement of those ends, they have at all times an unalienable and indefeasible right to alter, reform, or abolish the government in such a manner as they may think proper. 2 years in a row, the House has failed to even allow the resolution to change our Constitution back to the original intent, purchased by sacrifice of blood and treasure, to be put on notice or taken up for consideration, not at the request of the sponsor, Representative J. Reedy, but by forces within leadership, within the power by law to keep it out of the hands of the elected employees we select to do the business of governance. There are leaders in the House who will say that they voted for the resolution in committee, but did they spend any political capital to advance it in finance, where it has died in successive 2 years? Any testimony on Nashville news stations as to the importance and necessity of letting the people decide the issue, or simple acquiescence to the heavy foot of leadership to keep this issue out of the hands of the people's representatives to decide, so that constituents can make an informed decision who to vote for or against in coming elections. In 2024, I testified in Senate Judiciary Committee on the resolution. It engendered the support from all the Republican committee members. And likewise, on the floor, every Republican senator voted to engross and send it to the House for action, where it was summarily slaughtered without the consent of the body, on paper anyway, stabbed to death by someone behind the curtain, a cabal nameless and so therefore blameless, using the Pontius Pilate gambit. The entire wad can wash their hands and say it was not me who choked the life out of that initiative. Thank you for the opportunity to address the Assembly tonight. I will close with this. Article 1, Section 23 of our Declaration of Right charges each of us to instruct our representatives. Each of us. If you fail to do that, can you really look your children and grandchildren in the eye and say you did your best? Have a good evening.